The CRS Firearms case with Matt Hoover, which ended with a conviction for both gentlemen involved, is a lot crazier than you think. A lot crazier than you think. I'm going to be quickly busting through this and giving you what you need to know, and you're going to see just how crazy this sort of stuff is, and also why you hear attorneys like me, and I'm sure others as well, cautioning people about things all the time on the internet. Because the internet, it's very real. And it sometimes comes with federal indictments. So guys, a lot of crazy stuff to cover here. Let's get into it. So for those of you living underneath a rock, what the heck are we talking about here? Well, there were basically two guys who came up with basically something that resembled about the size of a cell phone, except it was a flat piece of metal. And supposedly it was marketed as if you cut along some lines that were on that piece of metal and you could create what's called a lightning link out of it. What is a lightning link? No need to Google. I did it for you. Basically, it was a device that was developed in about the early 1980s to convert a Colt SP1 AR-15. So keep in mind, back in the 80s, we didn't have a million different types of AR-15s. There was just only a couple manufacturers. And that was with a civilian bolt carrier group to basically fire in full automatic. So these lightning devices, they were finicky, they were gimmicky, and they often broke. They were sometimes very brittle and fragile and so forth. They also explicitly were a machine gun part under the National Firearms Act, and of course had to be registered as part of the May 19th, 1986 amnesty under the Hughes Amendment as part of the Firearm Owners Protection Act. More on that in another video though. But just keep in mind, a lightning link is basically a drop-in part used to convert a semi-automatic AR-15 into a full automatic fire. Okay, so these guys, Hoover and who had it's still out there, a firearms channel on YouTube called CRS, basically was marketing and was selling these plates, these metal plates. And he said, look, this is basically, it's kind of like an homage. It's a tchotchke, it's a knick-knack, it's something like that, right? But of course the ATF didn't take it that way. And they wound up filing federal charges against him, saying that he was distributing, selling, marketing machine guns. At trial, the ATF put on, I'm going to just focus on 4 witnesses here. 3 of them were buyers of the product, and all 3 of them said that they thought that they could cut along the lines that were on the card to create a lightning link. One, however, acknowledged that when he tried doing it, he could not get the device to work and threw it away. Okay, so the ATF led with these 3 buyers who all said, yeah, basically, I all thought this, so this is the intent, this is what I thought I was buying. Didn't work, said the one guy, threw it out. Okay, so then they dropped the expert. Their hammer came in. So the ATF experts said that, look, I followed the lines on the card, and I couldn't get it to fit into any AR-15 receiver that we had for testing, which I'm sure is more than 1 or 2. Okay, great. Couldn't even get it to fit in an AR-15, so we're kind of done here, right? Can't be a machine gun if you can't make it work. Right? He didn't stop. So then he said that he basically wound up breaking out the Dremel, ignored the lines, and just took the metal that was sold and the concept of how it was sold of, oh, you can create this from this piece of metal, you can turn it into a lightning link, and invented a new product. And I say invented a new product because that's what you're doing when you're ignoring the product lines and the material here. You're just taking the material that was sold with the concept of how it was marketed, and you're inventing your own product using the same materials. And that's what they sold to the jury, is that by taking that product, that piece of metal, which I think is incidentally about 50% more thin than the old lightning links were, that eventually after 40 minutes of dremeling, he was able to, with only selecting certain light primer ammo, able to make one AR-15 shoot 5 shots, and that's it. That was their case. That was their case for the fact that all these machine guns, if you drill along the lines, hey, whatever. Apparently you don't have to drill along the lines. The simple fact of the matter is that, in essence, the ATF got convictions because they said that these guys sold people a sheet of metal with the concept of what you could do, and that's good enough. That's a machine gun now because some guy was able to do it with a Dremel and enough parts to eventually swap it around with selecting special ammunition. And oh, by the way, he had to use a military-style bolt carrier too. So again, not even like the original SP1, the civilian bolt carrier group. He had to swap in a whole different military style one. That's what they got here. That's what these two guys now are facing decades in prison for. Hoover, they're yet to be sentenced at the time of this video, but Hoover's looking at 45 years of federal prison, and Irvin, who's the guy who manufactured actually, is looking at 110 years. And he's been in custody for the 2 years without bail during the pendency of this entire case already. So even if this whole thing gets overturned on appeal, it's not like he gets those 2+ years back at this point. So what are some big takeaways that I want you to take from this? Number one, prosecutors can and will charge people for things that you and I may think are crazy. Absolutely crazy, and no one would even think about charging. Because I'm sure that if Irvin or Hoover thought, oh, hey, I could get charged for this, maybe they would have rethought their process. I mean, maybe not. I realize there was some kerfuffle and controversy about this. I'm not wading into all that. But the point is, for the next Irvin and Hoover who start thinking about these ideas, while we may be united and agree and stand shoulder to shoulder on the fact that this ought not have been a conviction, this brings me to number two. Juries are not gun people, and they may buy what the prosecutors are trying to sell. Because again, I don't understand exactly how the ATF was able to sell this as being a machine gun. It's a concept and material. That's what they said. Concept and material. Good enough, apparently, according to this jury. I would understand if you maybe, like it would be a big step towards conviction. Let's put it that way. If at least if you cut along the lines, right, that, well, now, okay, through some sort of constructive possession, if you had a Dremel or a proper cutting tool on you, using the early 90s U.S. Supreme Court case, which we reviewed in this channel, linked in the description box below, talking about Thompson Center, that, well, okay, if we have all the proper tools here in order to cut this and configure it into a machine gun, then that may be a really weak and flimsy case, but at least I can see the logical jumps here. I do not see the logical jumps in the fact that they had to design an entirely new product and ignore the old product and just simply use the same material. That does not make sense to me. But again, this is the important thing, is that while juries, I think, are great at usually getting it right, they do not always get it right. And the time that they don't get it right, that might be your case. Which brings me to point number three. While Hoover and Irvin have strong defenses and should not have been convicted, there is a such thing as poking the bear. And this is exactly what it looks like. If you don't believe me, check out some of the content that's out there as far as how this stuff was being marketed. It was very, well, I know my rights, come get us ATF. And again, I'm not trying to encroach on his First Amendment. This is not about First Amendment. If I put on a shirt that says, I like to hit people with cars, and then I go out and hit people in my car, they will absolutely use that against me at trial for the fact that I intended to hit people with cars and I'm a bad person and reckless and ought to be convicted and yada, 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 right? I have a First Amendment to wear that shirt, but the government is absolutely going to be using that against me in this case as well. And it's the exact same thing here. This is just poking the bear. And I don't know if it probably would have eventually happened, but a big part of the government's case here was going on how this was marketed, the videos and everything else. Just like, incidentally, the government, a big part of the ATF's case in the pistol brace rule, which God willing is going to be overturned. And we've done a lot of videos on that as well in this channel. But just as the fact that the government has relied heavily on community use, pictures, YouTube, all this kind of stuff. Okay. So again, what you do on the internet, with your friends, being recorded, whatever, this can all come home to roost, and no, that is not a First Amendment violation. Before I get to my last point, if you've enjoyed this video, please consider clicking like, subscribe, share, make sure you don't miss any of our future content. We do a lot of fantastic things. I'm biased, but you know, Derek, the cameraman behind the camera, and our director will probably throw something at me if I say anything otherwise. So there you go. He's nodding with a gentle smile right now. Menacing, but gentle. So number four, the internet is still part of real life. You've heard me allude to this so many times, but guys, what you say and do on the internet will absolutely haunt you. The social media posts that you make about shoot, shovel, shut up, oh, my back 40 is my evidence disposal pile or whatever else. Yeah, you have a First Amendment right to say it, but it's going to be really prejudicial if and when it comes into your trial. And I understand, like I can hear the keyboard warriors, well, that's what a good defense attorney can do. That's not the way it works, okay? A good defense attorney, I can't go in with a pair of scissors and cut out prosecution's evidence. The prosecution can try to submit it. The judge is going to be the gatekeeper in what comes in or comes out. And what will come in or come out will vary a lot from judge to judge. Some judges are very permissive about what is allowed to come in on basis of relevance, all this other kind of stuff. Others may make good calls, bad calls. Some may be a little bit more conservative, you name it. But the point is that there's a very real chance that if the prosecution finds your comments, all that kind of stuff out there, it's going to show up as an exhibit at your trial someday. So I'm not saying that to step on your First Amendment. Lord knows, I know someone in the comment section is going to say that. I'm saying this to you as an honest warning that you need to be careful, because I don't want to see that happen to an otherwise good law-abiding person who's trying to make some jokes on the internet or is trying to post some sort of meme that was funny or whatever. All right, be careful, be responsible. And as always, I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.